Agenda item 4B, which is health trust refund. I bring this up because there seems to be some misunderstanding. I'd like to clear up any misunderstanding regarding the health trust refund received by the district. As such, I will read the letter from District Council on the matter. District Council is Sewell, Leslie, Kidder, Sayward, and Lohman in Salem, New Hampshire. The letter is written to George Stokinger. Dear George, this letter is a follow-up to our conversation today regarding the Timberlane School District's receipt of approximately $855,000 in net funds as a refund for the over-expenditure of health insurance premiums the district paid on behalf of employees. As I understand it, a question has been raised about whether the district was required to hold a public hearing before receiving the refund. As I told you on the phone, the answer is no, unless the district plans on expending a portion of the unanticipated revenue. Under RSA 198:20-B, the district has the ability to appropriate and expend money over the bottom line of its budget if the funds received were unanticipated and received during the course of the school year. If the amount of money received from grants or other sources exceeds $5,000, the school district must schedule and hold a public hearing prior to the expenditure of the money. The expenditure of the money also cannot require expenditure of other district funds except those lawfully appropriated for the same purpose. The expenditure is also exempt from all provisions of RSA 32 relative to the limitation and expenditure of school district monies. There is no law, however, that requires the district to hold a public hearing prior to receiving excess or unanticipated revenue if it does not anticipate expending that revenue. In the case where unanticipated revenue is to lapse to surplus at the end of the fiscal year, no hearing is needed. Under RSA 198:20-B, it is only when the district intends to accept and expend revenue received that the district is required to hold a public hearing. If you have any questions, please call. Best wishes, Gordon B. Graham. So, as I alluded to earlier this evening, we rely heavily on district council. We try not to bother them too much because we pay for every dollar every minute that we solicit their advice. But we do rely on them heavily because this is where they're experts and we're not. That is the response from the attorney, and that's our stand. We don't need a public hearing, and we are not spending the money. Are there any board members who wish to speak? Mr. Mascola?
Can you just address to the public who Leslie, Kidder, Sayward, and Hillman are?
Yeah, it's our district council. It's our attorneys. It's a group of attorneys in Salem, New Hampshire that we rely on for all advice, all legal advice. Thank you. Mrs. Green.
So, Madam Chairman, could you tell me why I was not permitted to see this letter of opinion before this meeting?
Yeah, because Dr. Metzel was out of the office almost every day since graduation, and nobody was allowed to see it unless they came in to discuss it with him and look at it with him, and he wasn't here. So it's not that you weren't allowed to see it, you were permitted to see it when you could make an appointment and sit down with the superintendent.
Which was never forthcoming in 2 weeks.
He wasn't here.
That is a ridiculous policy.
Well, it's not a
And
policy.
I know that Mr. Below saw this letter. I know that you saw this letter. I know that Mrs. Delfino saw this letter. I am an equal member of this board. I had every right to see this letter ahead of time, and it's nothing but obscene discrimination against me that I did not see it. Furthermore, if I had seen it, I would have been able to get another lawyer's opinion, because lawyers' opinions are a dime a dozen. You put in something, you put 25 cents in, you turn the dial, and you get an opinion. I have an opinion from reading the law. The law is very clear. It says for unanticipated funds in the amount of $5,000 or more, the school board shall hold a prior public hearing on the action to be taken. That is the law.
Okay.
I don't see any case citations in here. I see nothing.
Well, I will just say that we pay a whole lot more than a dime a dozen in terms of, if opinions are going at 10 cents per 12 opinions, I'd like to find one of those attorneys, because we pay a whole lot more than that. I'm sorry that you have such a low regard for attorneys, but that notwithstanding, I think Mr. Collins has something to add.